Okay, then
I may be wrong.
I'm happy to get on the record what I understand to be no longer before us.
I have
And
it
if you
also.
think it's more than that, we'll need to get Ms. Veal to confirm that she has.
You said, I didn't hear you. You said there was something after we had there was some when we had our pretrial motions that
Right.
they went through. And then there was another set that they.
In November.
November, yeah, I have those. too.
And there's actually a motion that was filed after, it may have been contemporaneously with what was stated in court. And so I've tracked all that, and I'll go through that and then we'll see if it matches up.
Fine.
That's what we'll work on.
Yeah, I have
We're on
to get
hold until IT can get here.
I'm not trying to be overly technical about that. I just wanted to make sure.
No, that's not technical. That's
Between us there.
fundamental. So it's good that you brought that up.
Well, I'm going to be grouping on the counts and so forth, but I was planning on stating that in a group of counts that are based on the same basic factual background, I was going to mention what counts were not included in the DV because they'd been dismissed.
Okay. And that's true for a few of if we group counts by an incident, a situation,
Exactly.
there's some that were dismissed and some that weren't. For example, the allegation that Judge Peterson let people in the courthouse after hours, the director has dismissed and some she hasn't.
Correct. And it
Okay.
tends to be based upon what particular judicial code they want to rely on for that particular incident.
Right. Oh, the podium is on. Hey, Ms. Willoughby, can you hear us?
Hey, good afternoon, Judge. Yes, I can hear you. I just can't see whoever's standing at the podium right now. If you wouldn't mind identifying yourself, please.
Sure, we'll do that and we'll adjust the camera, and I'll make sure everyone gets his or her name on the record so you're not guessing. If you would adjust that screen, because you're right, because that's what everyone will be seeing. It angles up, it rotates, so as long as you don't break it, move it so that you can be seen from a position where you're comfortable. It actually rotates without moving the base. There you go, turn it. So stand where you want to stand, and look at that, we can see you, perfect. And that means Ms. Willoughby can see you and she'll know you're the one who's talking. And so when we get started, we will get you to get your name on the record.
Mr. Taylor, you still representing the judge from South Middle Georgia?
Yes. Judge Reeves? Yes.
We don't have a date on that.
No, that's what we're talking about next. But he keeps talking about new cases he has. I get
I'm
nervous.
good now.
Okay, everyone's pled or settled?
Mostly.
Okay. What about the indentured servitude one? Just today. Oh, congratulations.
They went from 850,000 to 350,000 to 50,000 to 5,000, and I got them under 2,000.
That sounds like not a plaintiff's case.
It's not, I was on the defense.
Yeah.
Oh, you're on the good side.
Yeah. Was forced to work. I mean, it was a
Oh,
crazy situation.
I know.
Yeah, the indentured
Yeah.
servitude one,
Yeah.
like you can't make,
They should pay her.
I know, they should.
but this is where you can walk away
I
from it.
loved your argument.
She,
Did you read?
she's gonna pay like virtually.
Yeah, it was in the paper. It was a Cedra love fest.
Yeah.
Oh, I didn't know that.
Yeah.
She's gonna pay
I don't
virtually
read
nothing.
her. I haven't read anything she got right, so
But, I mean.
There's no more print
That's
edition.
all we can roll. Give it a do that.
Right,
So,
why do that?
right.
Just-
Just from a billion.
It's
to like-
such a healthy way to let go of it.
Yes.
Yeah.
Take that, big firms.
Yeah.
that was great. That was a good day's work for you.
So this morning. Thank God.
She's got to be ecstatic.
She's still pissed that she's gotta pay anything, but.
Hey,
Hey, so I think we've got I don't know if you did it remotely, but the podium is attached. Do you need your device attached? Do you care, Ms. Veal? Not your your personal machine is, or professional, but that device there is currently not attached. What do you see on the screen? Do you see anything?
The same thing that's up on.
Just use the
the
screensaver.
Just saying this.
Okay.
Okay, bring it up.
So would you like that machine attached or you're good?
I can, you'll have to make me a host and then I can just screen share it through.
Yeah, you won't even need to, I'll make sure you can screen share. Does anyone need the big screen showing what's happening at the podium? We may be good with just the podium then, because that wasn't on, and so our court reporter who's virtual couldn't hear, but she can hear now because the podium is on. All right, hearing no one else, I think we're good to go. Michelle will reach out to you if we've got a crisis.
Great job.
Appreciate it. Yeah, exactly. He usually shows up. It's like, you made me come all the way down here for what? All right, then if everyone is ready, let's get on the record. Sorry that we had about a 10-minute delay. This is the final session, I believe, in the matter concerning Judge Christina Peterson. And today we are covering two things, the directed verdict argument from the defense or from Judge Peterson, as well as the director's presentation of any response beyond what's already been presented in writing concerning the directed verdict motion, and then the summation from the director. We already had Mr. Tate's summation back in Cobb County when we were last together. We've got about 90-ish minutes, but no one needs to take all that time. We will take it from there. I will get on the record now my understanding of the counts that are no longer before us, 5 through 12, 16 through 18, 20, 22 through 24, 27, 29, 36, 45, and 47. That universe consists of two different steps that the director has taken. There were some counts withdrawn before we started at all, way back when, and then there were a handful of counts that were withdrawn in November. But if you combine the two, you get that. Ms. Veal, does that comport with your understanding of the counts you've withdrawn or dismissed, whichever verb you want?
Yes.
Okay. Do you have anything different, Mr. Tate?
I do not. That's correct, Judge.
Okay, great. All right, then by agreement, we're going to take things a little bit out of order. I don't know if it's out of order. We're going to start with the presentation from Judge Peterson's team of lawyers on the directed verdict motion. We've read the motion, so you don't need to rehash what's in the motion, but there may be things you want to supplement through oral presentation. But if you would, for the court reporter, state your name and then dive into things.
Good morning. My name is Dwight Chamberlain, and I am here on behalf of Judge Peterson from the law firm of Aiken and Tate.
All right, when you're ready, Mr. Chamberlain.
Thank you very much. Please, the court, this is Judge Peterson's motion for directed verdict in accordance with 9/11/50. It is going to be addressing a number of counts, and there are quite a few. And what I would like to do to speed things up and be able to take this within my 30-minute time period is to generally set out right now what the legal basis that I will be relying on each of the individual counts that have been charged. So they will be related back to those authorities. And to start out, obviously this is a motion for directed verdict, so relying on OCGA 9/11/50, it is our position that all of these motions that I'm about to make are based upon the fact that there's no conflict in the evidence as to any material issue, with the proper reasonable inferences drawn from that.
Mr. Chamberlain, before you go any further, much of the thrust of your written motion had to do with, I'm going to call them constitutional challenges.
Yes.
The rules are too vague or whatnot.
Due process or First Amendment analysis, correct.
As opposed to, hey, if you look at the evidence that's been presented, there's no conflict in that evidence and it doesn't support a finding that Judge Peterson violated
Correct.
Rule X. I wasn't expecting that you were going to do much of that and that you were going to focus, you're going to be able to cover whatever you want. But your motion was all about the constitutional issues that might be seen as arising from proceedings against a judge where she's exercising free speech, for example.
Right.
Is that where you're heading with this? Because what you just said about there's no conflict in the evidence made me think, at least, that we were going to be getting into, well, you know what, you should give a directed verdict on count 21 because there's no conflict in the evidence that the courthouse was closed. Mm-hmm. Is it going to be more like that, or are you hewing to what we read, which was more of an attack on the rules as written and as applied to your client?
No, I'm not going to be. My understanding of the directive from this panel was that you had the brief. It was very extensive. that I understood to be that you wanted me to stick to basically the factual conflict of evidence type of argument on the remaining counts and to leave out further argument on First Amendment analysis or due process analysis based upon vagueness or ambiguities within the
Great.
charging documents.
Good.
So I was not going to be re-arguing that. I will certainly entertain questions if you want to, but yeah, my time is limited. So
Yes.
I know.
Okay, good. No, that's helpful to know that you're focused on the more
Right.
traditional directed verdict
Correct,
argument.
it is traditional.
Now,
And
okay.
now, to that extent, and I'm glad that's a perfect entry into what I was about to do here. To that extent, my First Amendment arguments and due process arguments dealt with counts 1 through 4, and I think, memory serves me, 15 through 16, I think that was really the focus of those First Amendment analysis. To that extent, and I touched upon this in the 5th point of that brief, which talked about the effect of Coomer on my First Amendment analysis due process. The only thing I want to say right now is, first of all, I obviously am referencing that brief without further argument, but it is part of my motion for directed verdict. Secondly, I will say that I am making a motion for directed verdict on the factual basis. If you were to put aside the First Amendment law and analysis and just review it and say, okay, this is the rule, is there a conflict of the evidence or are there no conflicts of evidence on any material issue such that by clear and convincing evidence, she violated these rules that are now subject to First Amendment attack? I am going to make that argument as to those counts as well, because I feel that there is not sufficient evidence by clear and convincing to suggest or to show that she willfully violated any of the rules, or that she had willful or persistent failure to follow those rules, or that she had any type of conduct that was prejudicial to the administration of justice. Those are the basic elements that really are applicable under the state constitution to this case. There are a couple others, but I don't believe that they're applicable at all. So to that extent, I say that when you talk about the Rose Bar, you talk about the trifecta, you talk about the homosexual video, you talk about some of the other social media evidence that's been brought in where she was not acting as a judge, it was all extrajudicial. When you look at those and you look at the rules, you will see that from the evidence that there really isn't any conflict, but these did not rise to clear and convincing evidence that she would willfully win out and try to use social media to violate a well-stated, clear rule that she was not allowed to do what she did.
So you're using Coomer to say there's no bad faith?
Exactly.
Or that she didn't know anything?
Both. You know, bad faith.
You seem to be saying the Coomer decision is incorrect.
No, Coomer is correct.
You're kind of schizophrenic about it.
Coomer, well, under the state constitution, you have the concept of willfulness. You have the concept of willfulness. Did she willfully violate any of these rules? Under the Coomer decision, you have the concept of bad faith, which is a more malicious intent according to the definition that Coomer gave of bad faith.
So for a judge to violate the Code of Judicial Conduct, you're saying there must be an actual intent for that judge to violate that specific code?
Are you talking about just these counts that I'm talking about?
Yeah.
I would say an absolute level of mens rea of willfulness or bad faith. Yes, sir, because it's extrajudicial. Every one of those activities were not taken while she was on the bench. They were outside.
They were taken while she was running or was a judge-elect, right?
But I don't believe.
Do the same rules apply?
I do not believe so, and I believe the Supreme.
When I'm interrupting you, don't interrupt me.
Okay.
Do the same rules apply to a judge-elect and to a candidate that apply to a sitting judge?
The standard of proof is different. The rules, according to.
With regard to, I'm just dealing with your claims of First Amendment under the Georgia and the U.S. Constitution.
Yeah, the standard of proof that, okay, let me try to understand that. The standard of proof, and we're just arguing evidence here. We're not arguing the First Amendment analysis, if I understand your question, correct?
No, my actual question is, what, if any, how would you write the rule? A couple of times in your brief, you talk about the writers of the rule said this, that, and the other thing.
Right.
I was on the committee that wrote the rules, albeit I was the dumbest guy in the room, and nobody listened to me. So I remember what we were thinking when we wrote the rules. But they're not, these are the Supreme Court's rules, right? And you're saying they're unconstitutional.
Well,
Why are we the appropriate body to rule on the Georgia? I mean, they've told us a couple of times our role. What gives us the authority to rule on the constitutionality of the Code of Judicial Conduct that they implemented?
well,
That's my question.
there is an overlap here a little bit, and I understand your point. Where does the jurisdiction of this body come in as opposed to the Supreme Court reevaluating its rule? First Amendment issue we wanted to preserve for appeal, as well as the due process. So we're preserving. Whether you have the jurisdiction to overturn those rules, I would agree. That is a question that is probably subject to debate. I will say this, though, there is a bit of an overlap to it, and that is what I'm touching on here. If you have a vague rule that is subject to interpretation, that is confusion, that is ambiguous, setting aside due process, how, and this is a real practical problem, I grant you, how does a body such as yourselves determine, well, this judge willfully violated the rule, for example, 1.3, lend the prestige of their office for financial, private, or third-party interests? How do you interpret that if that rule is vague so that a judge who is reading it interprets it one way, and we then look at the rule and say, well, you know, that is subject to interpretation. How do you ever reach the level of willfulness? Because the Supreme Court Constitution, the state constitution says you sanction for willful conduct. So if there's a subject if there's an issue of interpretation, how do you ever reach willfulness?
Well, what if that judge has an interaction with the JQC, and the JQC provides some guidance as this is what the rule means, and then the rule's violated again? Does that not show willfulness? You could always say, I don't understand the rule, but if the folks who are tasked with interpreting and enforcing the rule say, this is what it means, and after that interaction, you profess confusion and use that as protection to violate it again, why should we not find willfulness from that? Self-imposed ignorance is different from, I didn't understand it the first time, but I had an interaction with the JQC and they explained it, but I'm going to pretend I didn't understand.
Well, I think willfulness is probably a subject that is always up for debate in a trial, right? I mean, that could be said, but just not with this particular constitutional argument.
It's not, no.
But I mean, you can decide whether or not something's willful in any context, not just a First Amendment.
Right, but you didn't answer my question other than to say willfulness is up for debate. I'm asking you, what would be incorrect in this panel finding willfulness from perhaps an innocent, I don't understand what this rule means. I don't know that that's what we'll find, but just benefit of the doubt. I don't understand what this kind of plain language rule means. Okay, let us tell you, investigative panel, director, let us tell you what it means. And then there's another issue with that rule. And the response from the judge is, I just don't understand what the rule means. Those are the words coming out of the judge's mouth. Why shouldn't we be empowered to say, that's willfulness. You were told what it means. You don't get to say, I still don't understand it when it was explained to you. Where are we left with that?
Well, I mean, it's a hypothetical.
I don't know how hypothetical it is, but I'll let you answer it as a hypothetical.
Well, as a hypothetical, I think it depends on what the explanation was that was given to that person and whether it was in fact a correct explanation as to the application of the rule. And then unfortunately, as I was trying to address this issue, if the explanation is still violating First Amendment rights, does that mean the person is shut down with First Amendment?
What limits are there on a judge's First Amendment rights, or are there any? And it seems to me you've made your argument in the brief, and I guess you're reserving your appeal. I'm writing 1/3 of this decision. I got a bunch of questions in your time. What would you have a rule say that would regulate the speech of a judicial officer?
I can speak to it from the context of this particular case because I can't possibly speculate as to how this may come before.
Well, let me just ask you. You say it time and again that the judge on her personal time did thus and so. I don't know that makes a difference, does it?
Well, it
What
does.
does personal time for a judge mean?
Well, first of all, the personal time is that it's not on the bench. She's not engaged in performing judicial activities.
If you look at every complaint since 1972 that I'm familiar with, the actual complaints that occur from a judge sitting up in here are probably less than 10%, right? So you're saying acting on the bench as a judge, those don't happen that much. If the rules are so hard to follow, how come in at least 20 years, we haven't had any of the issues, hardly any of the issues that your client's charged with? Most judges understand.
I can't, I mean, you're making a statement that I can't argue with if that's what you believe. I will say.
I don't know, I'm asking.
Yeah, I will say that if we're going to the First Amendment analysis, that as I have spelled out, that these rules are subject to interpretation, and most importantly, these rules are subject to the effect on the listener. So every time a violation is lodged against Judge Peterson, it's based upon the interpretation of what she said and the effect it had on the listener. And under First Amendment analysis, whether it be state or whether it be U.S. Supreme Court, it is uniformly held that when you must revert to determining what the effect of the speech is on the listener, it is content-based restriction, and therefore it is subject to strict scrutiny, and it has to be narrowly confined so that if the rule could be applied in a situation that does not meet the compelling interest for the rule, it is violating First Amendment. That's the way First Amendment works.
For First Amendment rights violated, wouldn't that be irreparable harm?
Well, I think First Amendment is a harm. Whether it's irreparable is a question of whether it's remediable.
One of you smart folks say that any violation of the First Amendment is irreparable harm. You've never heard that.
Well, for purposes of filing an injunctive relief, yeah, I've heard it. But for purposes of whether or not First Amendment rights has been violated, irreparable harm is not an element for analysis.
I want to make sure you've got enough time. which
Yeah,
is
I know.
right now,
I'm down to 18 minutes.
Cover well, but these are all important questions, and you asked to have an oral presentation. You don't have to answer questions when you file a brief, but here you are.
Got
And
you.
so you're open to questioning. But I want to make sure that you touch upon where you think there are no conflicts in the evidence and the record as it stands doesn't support
Sure.
a finding that by clear and convincing evidence a violation occurred.
As to the first, so we'll go with counts.
Whatever counts you want to do in your remaining minutes.
Okay, as I was talking about the counts 1 through 4 and 13 through 15, with the Rose Bar, the social media, they're extrajudicial. I do not believe that the evidence supports, and there's no conflict in the evidence that it supports by clear convincing evidence that she willfully violated any of those provisions. They were subject to interpretation. I don't believe there's any way, especially the ones lending her prestige for office, I don't think there was any evidence at all offered suggesting that by any of these social media, people got the impression that if they came before her, she wouldn't be impartial. If they came before her after going to her performance, she wouldn't be independent, or that her integrity of managing a hearing before her was somehow compromised. And you have to realize that counts 1 through 4 and 13 through 15, we're talking about those types of canons, 1.2A, 1.2B. And that's what the focus of the director's charges are. And I don't believe they met that level of proof. All right, the second category that I would like to move to would deal with, and I've categorized this as category number 2. And this is involving the wedding party, and I'm going to take the wedding party and after-hour access charges, incidents together. And what those counts are covering are counts 18 through 21, and I realize 18 and 20 and 23 and 24 have been dismissed. So whatever's left between 18 and 21, and 27 through 30, and not including 29, that has to do with the emails, the request for a sheriff, that type of incident. And I'm moving for a directed verdict on that. So let's talk about the wedding party incident. I will summarize it briefly this way. is that if you take the evidence as a whole, you see that what the policy was on that day was subject to confusion. The sheriff Sheriff Clayton, who had been doing weddings there for, I can't even remember how long, but quite a number of years, was not even aware of many of these policies. For example, putting the people through the machine for scanning, was not even aware that was required. We have a chronology of events, as I remember the evidence, which was that Judge Peterson, who has been charged with that wedding party on certain violations, like primarily she didn't cooperate with judicial personnel. And that's the big one. I know that there was also, I think, 1.2B, which is that she didn't maintain the high standards to promote independence, integrity, and impartiality. But I think the focus, the thrust of the director's prosecution on that is that she didn't cooperate. In other words, she ignored a directive from somebody not to go into the courthouse. That's the essence of it.
So dovetailing on Judge McBurney's earlier question, if Judge Peterson was told not to do something, or was, the new policy or the procedures were explained, and then she went on and did the opposite of what she was directed, is that not a willful violation?
May I, in the context of your question, assuming that she was given the final word that she was not to enter, for the purposes of motion for directed verdict, yes, you would say you're not entitled to it because there's a conflict there. For purposes of whether there was clear and convincing evidence to sustain a conviction on that, that's another question.
So the sheriff and the major telling her not to go in is not clear and convincing?
Well, that is not my recollection of what the evidence showed. Now, it may be different, but from the purpose of my motion, the chronology is as follows.
But isn't, just so you don't spend too much time on certain impossibly uphill battles, the standard for a directed verdict is that there's no conflict in the evidence. And I believe there is a conflict in the evidence. Whether it's clear and convincing or not, let the jury decide. But there's clearly a conflict in the evidence. Judge Peterson's testimony was no one said no. The schedule was wrong, and I showed up, and I see someone doing what I'm trying to do, and so I did what they did. Okay, that is a version of events. Other people testified under oath. I said no. That's not what Judge Peterson recalls. That's a conflict in the evidence. So we need to work out, does that get to clear and convincing? Do we credit Judge Peterson's recollection? Do we credit the other person's recollection? Why were some phone calls recorded on this special app and others weren't, or at least weren't produced? We need to work through all that. But how is there no conflict in the evidence? Because there are two different arguments. No conflict. That's the only argument you can make right now. Does it rise to clear and convincing? That's Mr. Tate. He already argued that. That's the summation saying, yeah, you know what? It looks like there were some mistakes made on that day with the wedding, but they don't rise to the level of clear and convincing. And even if they do, they don't violate a rule. You're stuck with a really tough standard. No conflict. I'm telling you right now, there is a conflict in the evidence about that after hours wedding because people under oath said we told her not to do it. We're done. I mean, you can spend another 30 seconds on it, but.
Well, I want to make sure I make the record because I don't agree with your analysis of the chronology of events. That said,
Okay.
I respect that is what you have already, in your mind, it appears to me, you have already concluded were the chronology events, and I don't want to spend my time trying to convince you otherwise.
All right, we will
But
certainly.
I do want to make the record clear that I do not believe that the wedding party allegation has been supported by sufficient evidence and that there is no conflict of evidence as to any material issue.
Okay.
And that's where I think we may have a difference of opinion.
Yeah, don't go in is a material issue, I think, in the panel's mind. But we'll work through that outside the context of directed verdict.
And I'll also say that my feeling is that directive was, there's no conflict that directive was withdrawn once she spoke to Sheriff Pounds.
Okay.
Okay. So I've made my record. I do move for that on those counts that I've mentioned. The other one was the after-hour access charges, and that was counts 27 through 30. Again, that has to do with, I think, the response to Judge Emerson, the email. There was a strong email, obviously. And there was also some requests for sheriff escorts after the penalties were imposed. I'm moving for directed verdict on that because I don't believe that her actions in responding to Judge Emerson was willful misconduct of any particular rule. I believe that a reasonable analysis.
Before you go on, the willful misconduct, the willfulness, this isn't extrajudicial. This is now work related.
That's correct.
Okay.
That's correct. But in this, I'm not saying bad faith, I'm saying willful misconduct because the Supreme Court, the state Supreme Court talks about one of the grounds for removing a judge is willful misconduct.
Okay.
And I'm saying this is not
Okay.
willful misconduct. All right. And so I think she was asserting what she believed to be her, maybe she could have put it more artfully, less.
Maybe?
Look,
Could you have made it worse without it having some four-letter words that weren't in there?
I fully acknowledge the language is strong. I do.
Let me remove the word maybe from that sentence.
All right. I have seen pretty strong languages from the bench sometime too, so I'm picking my words carefully. But that said, I just don't feel that there's clear and convincing evidence of willful violation of the rules that were asserted in the complaint as to those counts concerning Judge Emerson, the letter to Judge Emerson. She reacted based upon a long history with Judge Emerson. She reacted because Judge Emerson basically tried and convicted her without ever even talking to her. So I have problems with that on a clear, convincing level. The request for the sheriff, again, I understand your point and your questioning during the course of the trial. Why are you asking for a sheriff at 3:30 a.m. in the morning? This is a situation where it becomes, a reaction to her wanting to assert her rights. Now, you have to ask yourselves from a motion for directed verdict, is there some conflict? I don't think there's conflict. I think it's a question that whether or not did this evidence meet clear and convincing standard.
Which I think that's true for a number of these counts, and we're going to hear from Ms. Veal on that. And that's what Mr. Tate touched on. It's just not a directed verdict question. So maybe that happened. Is that clear and convincing evidence of a violation of the alleged rule?
Absolutely.
We struggle with that, no doubt.
I understand. And I'm not here to try to do closing and persuade you on that. I understand that. The intent to sue letter, absolutely no conflict of evidence in that. She said, I was going to sue you. That's not, there's no conflict in the evidence. That is not violating any rule that would govern a judge. Judges all the time threaten. I mean, there's a case right now with federal judges suing federal judges over wages. It happens all the time. Judges have the right, like any person, to suggest to the other side, look, my rights are being violated. In this case, she was acting as a judicial officer trying to get her software in place, and she was not getting anywhere. So she said, look, I'm telling you, I'm not getting anywhere. I'm going to sue. That is not a violation that requires the director to remove her or sanction her for exercising that right. She was trying to act as her officer. So I believe that should be dismissed on my motion for directed verdict. The next issue is the panic button. There was confusion in the evidence as to whether anyone was even instructed on the use of the panic button. Again, no willful misconduct, no lack of cooperation. The testimony, I thought, was pretty clear that people just didn't understand how that worked. She used it to get a sheriff. She used it to get a sheriff to get her to a court hearing to try to do her job. The sheriff didn't show up. She had cooperated by putting in a request. The sheriff hadn't showed up. She pushed the button. She did it one time. It was explained to her it was an emergency. She hasn't done it since.
It must have been a clear rule.
I think it was explained to her after the event, and I think that's what the testimony was. After it had happened, look, these are for emergencies. Oh, okay. It wasn't understood, and I think there's no conflict of evidence on that, and I think a direct verdict should be asserted on that count as well, on the involving the panic button. Obstruction of public records. That I think we're down to, based upon the dismissal, I think counts 25 and 26. And the thrust of the director's charges against her on those involve 2.5 and 2.12, which is basically making sure that the judge assures that there's competency of their staff and that they cooperate with judges and staff. That seems to be the thrust of the obstruction of public record viewing. And I would say that I think the evidence, there's not much conflict in that, because the fact is the judge wasn't there. The fact was the conversation was made with clerks. The fact is that the evidence was clear that the clerks tried to assist. The fact is clear that the software that was in place at the time, which was Judge Emerson's software, not the software Judge Peterson wanted, that software did not lend itself to being able to locate the particular document in question being requested. And once Judge Peterson was made aware of the problem, she immediately moved and assisted with getting the record. So the overall evidence does not support clear and convincing evidence that she violated any rule, and there's no dispute in the facts on that, and that should be a direct verdict on that one. Next. The next category would be the caveat of the will that was charged.
You're skipping over, you're not seeking a directed verdict as to jailing the woman who was trying to change her marriage record.
I was saving that for the last because I realized that you all would be very interested in that, and I'm trying to get through the ones, and
Okay.
I'm prepared to answer any questions on those, but I am going to get to that.
Okay.
And I am going to be arguing a directed verdict, and I'm certainly prepared for the fire of the questions from the panel.
Okay. Well, you got a few minutes left, so you prioritize how you want to prioritize.
Well, I'm going to move quickly. I'm going to be moving for directed verdict on counts 38 through 43 on the caveat of the will. Every one of those counts does not have sufficient evidence that she violated any rule. I think the testimony from the witness stand was fairly clear, even from the director's own witnesses, that she had the discretion to extend the right to file an objection. I think it was clear that she was acting, her office is both judge and clerk. She had an obligation to make sure service on the of the petition was served on the parties. It hadn't been served. She was trying to get service so that person would have their day in court. I think it lended itself to interpretation that she was trying to show to an out-of-state resident that she was being impartial and was trying to give them a fair shake in the courtroom. So I don't think any of those incidents outlined involving the caveat of the will had any evidence that supported a willful violation or willful misconduct of any rule.
I'm interested in what the defense, the respondent says about the jailing of the citizen. You're saving it for last, and he's going to throw you out about 3 minutes.
Okay, in category, okay. Let me then also go to letters of administration. Again, I'm moving for a directed verdict on the letters of administration. There was no evidence and no conflict in the evidence that there was any willful or deliberate or persistent showing on her part to not enter letters of administration. It was clearly from the evidence shown that there was obviously a filing of an order that had been signed, that got filed, but didn't get docketed in the electronic docket system. And so a clerk took it, and a clerk made the decision that they were going to backstamp him from training that they had received from prior probate judge. That should not fall on Judge Peterson. It should not be a grounds for removal, and it does not meet the clear and convincing standard. And since there's no dispute in the facts on that, I say that a directed verdict on that incident, that would be counts 44 through 50, should be granted.
Okay.
And now we come to the marriage license. Okay, the fact of the matter is that you have to look at several things. I would ask the panel to look at this for purposes of the motion.
Isn't
for
the
direct
best
verdict.
thing you can say about this is she learned from her egregious mistake and hasn't done it since? And so it's an example of learning from rules that she learns.
Even though on her testimony, she never told us that I remember, you know what, I probably shouldn't have done that. And if I lost my head and maybe I shouldn't have done that. Noted.
I understand.
How long was the citizen jailed? Do you know how many minutes or hours or days?
I think it was 2 days.
2 days, 48 hours.
Yes. And when you're done, I would like to comment on that.
Please.
Have at it.
The standard is willful misconduct by a judge. Let me ask you this. Would we all agree that the law schools and the courthouses are replete with cases of judges who've made errors in law related to suppression, related to delivery of discovery that should have been given under U.S. Brady, based upon violations of sentencing guidelines and misinterpretations of the law that have resulted in these very people, and don't let me leave out ineffective assistance of counsel. And those people have sat in jail for 5, 6 years, some of them on death row. How many of those judges right here in Georgia have ever been brought up by the JQC for a violation?
The director needs to look into that and send them to us if there's reason to do that.
My point is this, is that we have an issue here of the concept of contempt. Is it direct? Is it indirect contempt? I understand the concern about this. I do. And I believe she did indicate she would do it differently now. Perhaps it did not reach the degree of remorse that you wanted to see. But the fact is she did learn. And the concept of direct and indirect contempt is not an easy concept. Judges have gotten it wrong. That's why we have appellate decisions on it.
I don't know that that's what we're struggling with. I don't think I could tell you right now all the ins and outs of direct and indirect. It was the intemperance of the reaction as the worst, as I could understand it, that this young lady did is that she tried to correct a mistake on a marriage license. And so I think it's the nature of the reaction that you're going to jail because you perpetrated a fraud on the court. It's not the rightness or the wrongness. It seems like it may have been in error because I think your analogies aren't apt to say a judge made an error of law and suppressed something that she shouldn't have. Okay, that can be corrected. It's very different when a judge says, you've upset me, and because the way you've upset me, I'm going to lock you up. You're using a unique power that no one else in the room has when you lock someone up for contempt. And I think it's the disconnect that we're working through between the nature of the infraction. I mean, you have litigants who threaten the judge's kids in front of them, and the judge says, oh, that's too much. Deputy, take them out of the room. And then you have at the other end of the spectrum, I don't speak English as my native language. I'm trying to correct a document that I can't get a certified copy of because it's from another country. And I put my uncle because that's effectively the person who's been my father my entire life. And I figure I ought to correct this. Go to jail. It's the reaction to the circumstances and not the do you understand the ins and outs of direct versus indirect contempt. So you're hitting the nail with the wrong hammer on this one.
Well, let me.
That's the most significant issue to me right now.
I will.
Just adding to that, it wasn't just you're going to jail. It's going to jail for the maximum that I can give you, which is 20 days for essentially a mistake on a form in a court that does not typically send people to jail. It's the probate court. We're not talking about state court or superior court. So 20-day sentence, allowed to purge after 2. So you have to serve at least 2. It wasn't like purge right away. And just to add to that, I can't balance, because you just said on the caveat of the will issue that she wanted to make sure that the person got a fair shake in their courtroom.
I understand.
Not a fair shake in this instance.
Understand.
No right to counsel, not informed of the potential contempt. I mean, we're talking about every violation from a judge who practiced criminal law for the vast majority of her.
Who sent people to prison.
Right, who understands the right to counsel before someone's liberty is taken away.
But went out of her way to appoint a lawyer to this person from New York
To fill out
concerning
discovery.
this will. And here, I'm sending you to jail. No lawyer, nothing. I'll see you in 20 days.
And if there's a question or you wish me to comment on that, I would be glad.
Distinguish the two. You're telling us
I
that.
will. Let me distinguish it. There is a distinction between direct and indirect, and it's very.
Distinguish those. That is not what this is about.
Can I explain?
No, you don't, because you're out of time. And so what I'd like you to do is help us understand how we celebrate the fact that Judge Peterson got a lawyer for the out-of-state litigant on this situation where it was the year support or whatever it was called. And I understand it a lot better through the good argumentation and the witnesses, but we laud that. And somehow when the exact opposite occurs in this situation, no lawyer provided, go to jail for something that it seems much less consequential than the fact that a year's support would actually drain the estate. I get it now. That was helpful to learn. These are very different. And one, they're also inconsistent performances. So tell us why we should view this as, you know what, she just didn't understand the difference between direct and indirect, because I don't think that's the distinction to draw here.
Well, of course, I wasn't in the courtroom,
No.
nor were any of you. So.
But we did meet this infractor, and she did not strike me as the kind of person who was going to be aggressive with a judge.
Well, I realize that, but people can change when they are presenting testimony.
You-
And okay, I
Supreme
want to
Court
try to
can-
answer some of the questions.
Supreme Court can only give contempt for 10 days. Did you know that? She can lock them up for 20. She took the freedom away from the highest ranking class in our society, a citizen. And I'm struggling with that. All this other stuff is not an issue to me, really. I'm interested in knowing what your defense is on the locking up. And like we've asked you 6 or 7 times, what do you think the appropriate sanction would be, if anything, if she did that?
But here, the context is, because Mr. Tate's already talked about that very effectively. You're seeking a directed verdict on this. You got about 30 seconds to either say, you know what, I'm actually losing my credibility by arguing for directed verdict on this. And that may be why Mr. Tate stood up.
All I want to say, Judge, is that we have to make a record because
Right, that's what I'm
it's
trying to
going
do.
up, and we're trying to make a record here. And I feel like now, I argued the case the other day. These were things we felt like we needed to put the record in. So I feel like what we're now talking about is the same thing you were talking about with whether or not there's clear and convincing evidence versus what.
All I'll say is that in all the trials we've had, there haven't been many, all the final hearings, there haven't been directed verdict motions or making records on it. I'm not saying you can't. I'm not so sure where it falls in our authority, but I don't want to prevent you from making the record. Should you want to argue to the Supreme Court that there ought to have been a directed verdict issued as to the situation involving the jailing of the citizen?
You made your record with your brief. You kind of assumed the risk of this when you wanted to argue.
Well, no, the brief had the First Amendment.
Yeah.
Okay, this was not addressed in the brief. So yes, I am moving for directed verdict. Again, I understand the panel's concerned about it, but I don't feel that anyone was there to understand the credibility of that witness. We don't know what went on with it. I understand that the penalty was severe. What the remedy would be left up to you if there is going to be one, but I've made the record for the direct verdict. The last motion is going to be very quick. It's count 50, and that involves an incorporation of counts 16 through 49. That's basically a catch-all that we've charged all of these counts, and therefore that means there's persistent failure to do duties, and therefore we win on count.
Right, it's like
count
cumulative error.
Correct, cumulative error, and I'm moving for directed verdict based upon my other arguments.
Sure. Okay.
Thank you very much.
Thank you, sir. I wish you the best with your household emergency.
Thank you.
All right, Ms. Veal.
Your Honor, if I could have just a moment to get set up, I want to make sure that panel can see my presentation, and I think you will have to make me
Okay, try screen sharing. I
I'm
don't,
going to be over here on the TV.
yeah, actually, it's only going to appear on this. Can you see that?
Yeah,
I'll lean back.
I thought it was going to be behind Judge Lopez.
No, that's not connected, but does it not let you? I don't.
While we're doing this as well, Judge McBurney, would you mind telling me who's on the left and right of you, please?
Sure, I'm sorry. So on my left is Dax, D-A-X, Lopez, L-O-P-E-Z. On my right is Richard, standard spelling, Hyde, H-Y-D-E, as in Jekyll.
Thank you so much, sir.
And at the podium, well, there are two people at the podium, but the speaker will be Ms. Veal, V-E-A-L, Courtney.
Yes, thank you.
I think she's paying you, so you probably know her name. It says all participants can share. Is it not letting you do that?
It's not letting me do it, but it may be a me thing.
Well, let me do this. Now you're co-host. So you've got superpowers.
Judge, am I permitted to?
Please, yes, thank you so much.
Appreciate it.
Drive safely.
Thank you very much.
All right.
Pleasure.
I bet it was. Any luck?
No, Judge, and I think it looks like it may be a security setting.
I can try to get our IT person back down here.
You have it on handouts?
They said he's gonna give me the password. Screen on Zoom. No, you gotta change the, I'm ready for the rules, yeah, stuff now.
You guys gonna go to Orange Fitness?
That's just me.
We'll see you there.
That,
She could.
well, I don't know if you can control with the keyboard, but the device that's called Podium has a USB slot if you want to try putting it in there.
Yeah, for
legislature money.
Yeah, the governor allocated like 1.2 and we were looking for 2 point something. And so,
this just for Fulton or for?
no, it's the,
Accountability.
yeah, Council of Accountability Court Judges. So it would be, it helps Hall set up a DUI court. Paulding was going to get their first adult felony drug court, whatever the,
Yeah, you're not be able to get, is that startup money or is that something you have to have every year to fund?
it's startup money and then the
Like
county
organized.
needs to pay for it, or we can go for grants and things like that.
Have they done the pay raises?
What's the username?
I think so. I think it moved out of one committee. I don't think it changes things here. I haven't been involved in it. Are you good? Okay.
Ben, that combo's not working. Mm-mm. Can you email? Yeah. There's not. Can you email the presentation?
So could we get you to start and then we see if someone can make it work? Or I don't want to, if you're really married to the PowerPoint.
I can start without it, Judge. I have a computer though that apparently will work in the courtroom.
I don't
And I'm glad to have this subtracted from my time because I wasn't going to take all.
Okay, great.
So we're taking it off. It's right.
I just have pleas to take upstairs, so I got people stuck in cells.
Having been the victim of technology myself before, which is one of the reasons I was glad to argue and not use technology at the end, but if she wants to send the slides in later or whatever else, I mean,
Can you email them to us?
I can.
Great.
Put 'em up
If you
there.
email it to me, I'll just pull it up here.
Okay.
Maybe I can share screen. I'm gonna no longer have you be co-host. That's just, it feels a little cozy. There we go. So your schedule is opened up because of good outcomes. I need to find a week when,
I got a 2-week trial at the end of this month.
what is that? You mentioned that before. What is it? Where? Here?
Mark Cohen.
Yeah, but in front of Marco?
Yeah.
Okay.
That'll-
Yeah.
Something interesting. You got it.
Judge McBurney, I just sent the.
Okay.
We're operating in Georgia under. I didn't even know that.
We're operating.
What's that called?
Did you send them to me too?
I will.
Almost subpoenaing witnesses. Out of state, or can you domesticate this?
Or if you're in an out-of-state court, and just get out of that court.
Right. Yeah, we representing a commercial.
I shall.
As big as this now.
I don't have it yet. It's probably, you have to screen all her emails for content.
Is there a network we're on? Because I was going to get them to send her to me too, just so I can kind of follow along.
Can you take that man into custody as he's leaving? Thank you.
Hell, the ponytail.
Yeah. Yeah. Clearly not enough times.
Just telling me business.
Yeah. That's assuming you get out.
Oh, yeah.
What was the question? Oh, you need this, would you like the Zoom? You have the Zoom link.
Yeah, but I've got to get on a network
The
probably
Wi-Fi.
for Wi-Fi. And when I tried
There.
to connect to the public one, I got the Fulton County is down.
Yeah. The one this is on says FC Justice Local. Is that one coming up? What's yours on?
I'm on my hotspot.
Oh, you could share the hotspot. You have a cell phone?
Yeah, that's true.
Okay.
You can do that.
Do it. Did you, your email hasn't come through.
Yes, I do. Yep. Right, tap your phone. Looks like. Well, it's fine.
I don't have hard copy handouts that you can give us.
I know, this, I think that's the backup.
What are they gonna say? Code sections or something? What?
The PowerPoint?
Yeah.
I don't know. Maybe it's pictures. Depends who the speaker is. Sometimes it gives you something to do.
I've got it now.
I received it as well.
What?
She didn't.
All right. Can you try sending it to me? And making sure your attachment is safe. I see that. Yeah, they look judicial.
Looks good.
Yeah.
Very, very much so.
You got Title 40 there, just in case.
She wants to see what she let her back.
Okay, we'll do that. Worst case scenario. Let's do this. ID. Oh, why is that coming deep? So it's on the little screen right there. You can sort of see it. That's better than no screen. Okay. All right. Otherwise, you can leave it where it, you don't need to put it up here. Yeah. All right. Let me reach. Ms. Willoughby, you can still hear us?
Yes, Judge, I can.
Great. Well, we are going to now hear from the director. Ms. Veal is at the podium. When you are ready, ma'am.
I'd like to start this afternoon by thanking the panel for its patience and for indulging me in my presentation throughout this process. On my best days at the JQC, I asked myself why. And on my worst days, I'm like, banging my head against the wall, trying to figure out what we're doing and whether what we're doing is making a difference. And why am I doing this? Why are we doing this? And throughout this process, repeatedly, I thought about the hearing panel and the fact that each of you do this on a volunteer, unpaid basis. And so I know that if I was wondering why throughout this process, each of you had to be thinking the same thing. There are easier ways that we could have gone about resolving this matter, but we didn't. And part of why we didn't is the why. This is not about any of us individually, or this is the conclusion that I've reached. The JQC, either of the panels, it's about the public. And it's about the fact that this little commission is the only one in this state and other states that have similar commissions that can do the things that we do, and that can address, investigate judicial misconduct and demonstrate to the public, hey, there's somebody that cares about this, and there's somebody that is interested in ensuring that the integrity of the judiciary is protected, and that the public can have some level of confidence in what our jurists are doing. And so that's why we're here. The respondent throughout the course of this proceeding has focused a lot on the Coomer opinion of the Supreme Court. And obviously it's important. It directs our path forward, and we take from it a whole lot of instruction that we didn't have pre-Coomer. I read over it several times before today, and there were a few things that really struck me about that opinion. And there were just some portions of it that no matter how hard I tried, I knew I couldn't say it better than that opinion said it. And one of those things is on my current slide, and it says that our judgment is our only power, shapes the kind of conduct we must insist upon from Georgia's judges. The judiciary's judgment will be obeyed only so long as the public respects it. And that respect will not long survive judges who act in a manner that undermines the public confidence in their judgment and integrity.
I think we have it up now. So there it is on, is it on your screen?
It is
Look at that. Okay.
wonderful.
Better late than never. I'm going to ask you to do something. I don't think it's difficult, but I think it will help us focus. And that would be to do your presentation backwards, and I mean this only in one way. Let us know what you think, having heard all the evidence, the appropriate sanction is. Because the way I've followed your prosecution is that as you've learned more, you've adapted and shed some counts. As we've discussed things and processed things, I don't know, we're at the point, and I speak not only for myself, but it's after conversations. I don't think we're at one extreme or the other of the sanction spectrum. One extreme would be dismissed, directed verdict, nothing happened here. Something happened here. I don't think we're at the other extreme, which is this is someone who shouldn't be a judge anymore. It's somewhere in between. You're going to share with us your recommendation, but if you'd start with that, having synthesized the many days of the trial, that will help us, I think, process, as you say, here's why this is serious, because we'll know the conclusion you've reached, which is it's so serious that X should happen. Letter of reprimand, suspension, removal, wherever you are with this. And that will allow us, I think, to be better able to push back where we feel we need to push back on the conclusions that you've reached.
Sure. I'd like to preface my answer with this. We would not be here. I wouldn't be standing here. You wouldn't be tied up if just a few of the things alleged in the formal charges had happened, right? And obviously, any of them in isolation would not have us here. However, that's not the case. And what you have before you and what I believe has been demonstrated through the evidence is that we are dealing with a judicial officer that began violating the code when she became a judicial candidate, and it is continued at every step along the way. Judicial candidate, judge-elect, judge in the courthouse, outside of the courthouse, regardless of who she's dealing with.
But because the allegations involve such different conduct, the way you just portrayed it is infraction A keeps happening, but they're very different. And some of them, I think, lend themselves to what we heard from Mr. Tate, which is didn't know any better, learned, and hasn't done that again. And so I just think it's a different, as we're processing, it's different from saying, I'm making this up, stole from the till, stole from the till, stole from the till. After having been told the first time, don't steal from the till, kept doing the same thing. I think some of these, I'm going to let you know I'm a judge and I want you to go do this activity. That persists, and this real or feigned inability to understand the rules about that would be an example of something that persists. But most of these other things aren't good things that happened, but they don't recur. And so maybe I'm pushing back a little bit that it's not the same thing kept happening again and again. Different things happen. And so you're going to need to help us differentiate. I'm climbing a learning curve. I wasn't a judge. And to Mr. Lopez's point, I was a criminal law practitioner for the most part. And she has a much more diverse resume than that, but the bulk of it was criminal law, no probate experience. And so mistakes will be made. And we need to work through where were their willful actions versus I didn't know. I'm relying on a staff, and I didn't know they were backdating things. And once it was brought to my attention, they didn't backdate anymore. So that's I think what we're struggling with a little bit. The numerosity is great. So many complaints. I appreciate that there were some agendas at play with others who might want to bring them to your attention, but each incident was different. There may have been some intemperance that infected all of them with letters and I'm going to sue you and you should retire and you're a disgrace. But beyond that, they seem to be sufficiently different that we need to figure out, well, how much of it is you were learning, and after you learned the right way to do it, there wasn't an issue anymore.
And I certainly appreciate that. And I've thought through it. I've struggled over it. I would stand here today and probably ask this panel to recommend a public reprimand, but for the way that she conducted herself during the course of this proceeding. Because of that, which I believe aggravates, can be utilized by the hearing panel to aggravate whatever sanction it is that you recommend, I am requesting removal. In the Coomer opinion, repeatedly throughout that opinion, the Supreme Court noted that the hearing panel was the one judging the credibility of the witnesses, and you all made certain credibility determinations during the course of that proceeding that they afforded substantial deference to.
Reluctantly, but they did.
Reluctantly in Coomer too.
I was disqualified.
But they reference that throughout the Coomer opinion. And in fact, at the very end, when they ultimately say, we are going to remove Judge Coomer, one of the things they note is the seriousness of the transgressions, but they also note his response to the JQC inquiry, in particular, his behavior at the hearing. And there is a footnote in Coomer, and I've got it in here, that addresses, utilizing the way that a judge has behaved during the course of the proceeding as aggravation of whatever the sanction is that is ultimately imposed by that court. When we think through the available sanctions at this juncture, I would ask that the panel consider these things. The purpose of judicial disciplinary proceedings, I kind of view it as twofold. Again, it's to preserve the integrity of our judiciary and ensure the public that they can trust the jurists that they're coming in front of and the decisions that they make. That is number one. That is our primary purpose. But also, and I think sometimes this gets lost in the course of what we're doing, what we do here is also, or it should be, designed to give guidance to our judiciary about what conduct is acceptable and what conduct is not acceptable. And when the panel is considering, well, what sanction fits here, I think you have to consider that what you are deciding both speaks to the public and sends a message to them about what behavior is acceptable, but it also tells our judiciary and it sends a message to all of the jurists in this state about what kind of behavior is acceptable. And so it's not necessarily about punishing Judge Peterson. But when we are thinking through, again, what sanction here is the appropriate sanction, and I'll pose this as a question, will it matter at all to Judge Christina Peterson to have to walk into a courtroom and be read from a piece of paper that a Superior Court judge is reading, that she violated the Code of Judicial Conduct, and I'm going to slap you on the wrist for it. You are hereby reprimanded. Will that matter to her? The way that she behaved during this proceeding demonstrated to everyone watching, and I hope it demonstrated to the panel, that she has zero respect for this process. She over and over again was misleading. She over and over again changed her testimony. She came up with different explanations for her conduct. She over and over again refused to answer very, very simple questions, I believe, that were asked of her. Over and over and over again, she selectively produced evidence. She printed off evidence that she said at counsel table and then tried to admit it into evidence. And I don't think there is any greater demonstration of the fact that somebody is unfit to hold judicial office than the way that she conducted herself during this proceeding. She does not think that she has violated the code at all. In fact, I think would only accept a public apology from me for this entire ordeal. And that should disturb this panel the most. I believe in my closing, I talked about, going and presenting and training judges on judicial ethics. And I often tell them, my expectation is not for you to be perfect. And it's not that you're not going to mess up and make mistakes or just do really stupid things. Sometimes they're bad things. Something that is always incredibly important to me and the investigative panel, and I know it's important to this panel because I've read your opinions, is when a judge can come to the table and say, you know what, I was wrong. That was stupid. I was mad and I overreacted. I'll do better in the future. I won't do it again. Did we hear that during this proceeding? There were 2 occasions where Judge Peterson said she may do something differently in the future. The first one was prompting by Mr. Lopez. He asked the question, and it was about the email to Judge Emerson, and he asked, do you regret sending this email? She struggled to answer that question, but ultimately what she told you was that she would change the wording. That's what she would do differently in the future. The issue I have with that response, which was followed by all of the horrible things that Judge Emerson did to her that led her to her breaking point, was sending the email. The problem I have with that response is that there's no reflection on her end. There's no reflection about her behavior and how it may have contributed to the dynamic between she and Judge Emerson or anybody else throughout this ordeal, right? We want to know that a judge, again, a human judge, you're going to screw up and you're going to make mistakes. You're going to do things wrong. You will probably get reversed on appeal, but we need to know that you have learned from the experience and that you will do differently in the future. And do you know that about Judge Peterson? A public reprimand is not going to matter to her. We can't censure her or recommend a censure. A suspension then would be the next level of sanction. And again, from the Coomer opinion and reading some of our other opinions, the suspension has started to strike me as something that is really not at all much of a sanction.
Especially if you get paid.
What happens when our judges get suspended? Well, they get to sit at home, they're not doing their jobs, and they get paid. And so is that a sanction? Is that a sanction that is going to tell the taxpayers of Douglas County that we have taken this seriously? Is that a sanction that is going to communicate to our judiciary?
Are you
that-
saying
that-
we can't suspend, we can't recommend a suspension
No.
without pay?
I guess you could.
Recommend a suspension without pay?
You could make that recommendation.
Okay.
But for the taxpayers out in Douglas County, let's say you recommend that and the Supreme Court comes back and says, well, we'll do a suspension, but it's not without pay.
But that's on them. If, assuming there is authority to do it, I had the same question. I just figured I'd look it up because we don't want to recommend, we've made the mistake of recommending things that apparently are only for appellate judges, even though it doesn't say that in the rules. And so we'd want to make sure that a suspension without pay, if that's where the will of the body was a legally authorized sanction for ultimately the Supreme Court. And they're the ones who would decide, are we upside down, right side up on any of this? I just wasn't sure if you had grappled with that because we've struggled in a different case with a paid vacation. How's that?
We've done suspensions without pay before.
In the before times.
Sure.
Everything
You do
before.
it, yeah.
I understand that there's a provision in the law that essentially says that a judge's pay cannot be
That's
reduced
in the Constitution.
during their term.
Right.
And so I don't know.
We're not, I don't mean to put you on the spot, but that's, we have wrestled with that. Weren't sure if you had as well.
So let's say that the panel recommends a suspension without pay and that ultimately the Supreme Court says that that is legal and it's something that they ultimately impose in this case. So Judge Peterson is suspended, right, for however long, 3 months, 6 months. She's not being paid great, but the taxpayers and that money is going to go to whomever they have coming to fill in for her. So again, what message is that sending? The taxpayer is still having to pay for somebody to come and do her job because she's in trouble for the way that she was doing it and she's suspended from work. So that's the struggle that I have with our suspension sanctions.
But aren't there other sanctions that you folks can think of that are outside the box? I've said this to you and Mr. Tate several times. Imaginative things. She can check herself into the Douglas County Jail for 2 days and put on an orange suit. She can go to training at her own expense.
So there is a provision in the JQC rules that says other appropriate sanctions can be imposed. But my question is, what appropriate sanction is there that would accomplish what we need to accomplish here with this judge? I think there are other sanctions out there that for other judges might be helpful. Training, for example, requiring the judge to go to training. However, what we heard during the course of this proceeding was Judge Peterson has attended every judicial education training offered by ICJE since she took the bench, every single one of them. And I know, Mr. Hyde, you made the point during this proceeding to say, we don't do a good job educating our judges.
No, I think I said we do a terrible job.
Horrible. Failure at it. I think maybe the word failure was used. So I disagree, but I would remind you that the entity that decides who is going to come and do the ethics trainings to whatever class of court it is their court counsel, right?
Okay.
So if the JQC is not being asked to present, which for 2 years in the recent history by probate court judges, the JQC was not asked, right? So I don't barge in there and say, I have invited myself, let me tell you about judicial ethics. If any class of court wants to make a decision to not have the JQC come and present on judicial ethics, they do so at their peril. But that should not be viewed as our failure. That's not a failure of this commission. She's gone to every single training that's been offered. And in fact, you heard, and I thought this was very interesting, she's very smart. She graduated top of her class from UGA Law. She's got criminal experience. She talked about all the cases that she prosecuted and everything she did when she worked in Douglas County. She has civil experience. And one of the things that became very clear to me during the course of this proceeding is she's also very resourceful. If she wants to figure out how to get something done, she will figure it out. Before she even took the bench, she had made connections and contacts with other probate judges across this state. I think she listed out multiple counties that she called and that she consulted with. She talked about getting their policy and procedure manuals. They sent them over to her before she took the bench. She did this. Before she took the bench, she figured out how to do a budget pitch to her board of commissioners to get that software that we've heard far too much about. And one of the things that she testified to was she relied on her other judges that she called, and they walked her through all these things. She talked about having the probate judge from Gwinnett County come out and present to her staff and do a training on her staff, right? She had a probate judge mentor from an Article 6 court right next door to her jurisdiction that was assigned to her for the entire first year that she was in office. And she actually indicated she was smart, her mentor. She knew things about how an Article 6 probate court functioned, and she was very nice and very helpful, right? So the entire time during this proceeding that we're hearing about David Emerson, and he didn't help me or tell me, she's got a mentor for her entire first year in office. She's taking advantage of all the trainings that are offered to her class of court. She talked several times about doing research about these things that she's done before she held the woman in contempt. I did research. I reached out on my listserv. She knows how to do that. And so what I would ask of you is, for someone like that, that's gone to all the trainings and that has had a judge mentor and that knows how to make connections, knows how to reach out to jurists that serve her class of court. She knows all those things. She's done them. What is requiring her to go to more training? What is that going to accomplish here?
What would you have us give to the hostile environment out there towards her?
The obstacles.
That's my words.
The obstructions.
That was the word, obstructions.
Yeah. I mean, it was a rough neighborhood out there for her. What weight do we give that, if any,
So-
in your view?
I disagree some with that characterization. It was apparent to me, as I know it was you, that Judge David Emerson did not like Judge Peterson. But I'm not sure that in any jurisdiction in the state, the Chief Superior Court judge helps or trains or mentors or takes to lunch the probate court judge. And if they do, I'm not familiar with it. In fact, she said multiple times during her testimony that Judge David Emerson can't help me do my job. I do probate and he's never done it. At the same time she talked about Judge Emerson, she also told you that Judge McLean, who has been on that bench for a very long time, now the chief, she claimed that because she could not get help or guidance from Judge Emerson, she went to Judge McLean. And she said that he did help and guide her. So the characterization that the environment out there was hostile, I just disagree with. And if it was or did become that way, she contributed to it. Because she also told you, for example, with the weekend wedding incident, she testified that after Captain Wilson told her, do not go into that courthouse, she, because she had a good relationship with the sheriff, got on her cell phone, personal cell phone, called him on his cell phone, because that was the relationship they had. If she had something that she needed, she could call him. That sounds like a pretty good relationship to me. It's not a hostile relationship. And if that relationship turned sour after the wedding weekend incident or the panic button incident, whenever it was, again, my position would be that she very much contributed to it. She frequently referenced having to call commissioners, right? She would call them, she would go to them, she's adding them to the email strings as things are going on. So she had a relationship with the commissioners. So again, I do not agree entirely with that characterization. And of course, the panel can consider that. They can consider it. You can consider it in mitigation if you would like, but I just don't think it negates really anything that we are here for. So I'd like to jump to running through the formal charges. And Judge, I'm on the next slide. So this provision is contained within the scope section of our code, and I've never, since I've been here, I've not heard anyone reference it. The part that I think is important is that it says judges and judicial candidates should strive to achieve the highest ethical standards, even if not required by the code. The mandatory provisions of the code describe the basic minimal ethical requirements. Basic minimal ethical requirements that should govern the behavior of all judges and judicial candidates. During the course of the respondent presentation today, there was discussion about the fact that we've not seen other judges come in here with these kind of violations and all of these different violations. And I would submit to you, I'm not a judge, I've not worn the robe, but we have two panelists that are. The Code of Judicial Conduct is easy to read. I mean, it's not rocket science, it's tiny. It fits in this tiny little binder. This tells us these are the minimum expectations. In fact, do better than what is here. And it's not hard. It's not. Judges are going to mess up and they're going to make mistakes, but mistakes and messing up and coming and saying, I'm going to do better. I was a new judge. I didn't know how to do it. And coming in here and owning it would never have us here. But we are here because we have someone, and I agree with you, Judge McBurney, we don't have these same violations of these same code provisions for every issue that is before you. But there's something that kind of underlies all of it, right? And it's It's the why. And it's because we're dealing with somebody who doesn't care what the rules are or what the law says. And because there's no care for what the rules say or the law says, there are repeated violations of the code. It doesn't matter to her. If we could jump to the next slide. So what I provided here, this is just a summary of the counts contained within the amended formal charges. And of note, I know that we've already gone through which ones were dismissed by the director prior to this hearing were counts 5 through 12 in light of the Coomer decision. And counts 16 and 17 based on prosecutorial discretion. Those that were submitted to the panel where the director asked that the panel dismiss those counts during the hearing were 18, 20, 22, 24, 27, 29, 36, 45, 47, based on a recognition that the evidence came out in such a way that I was not going to stand before this panel and argue that that conduct violated these provisions. But what I think is important for purposes of right now is the requirement of demonstrating bad faith, or the requirement of the evidence demonstrating bad faith. And so I believe that requirement attaches to counts 1 through 4, which were all of the social media posts that occurred either when Judge Peterson was a judicial candidate or when she was judge-elect. I believe that requirement also attaches to counts 13 through 15, which is the conduct that occurred at the HOA town hall meeting while a judge. She was acting outside of her judicial capacity, so that requirement exists there. Moving to the next slide, the social media counts. So a few things that I would ask the panel to consider as it sorts through. And I think it is important to note, I think there's some conflation by the respondent in what the panel has to decide and what the standards are. And so number one, the panel has to decide whether or not the director has presented sufficient evidence to demonstrate by clear and convincing evidence that Judge Peterson has violated the code in the way alleged in the counts. That's number one. Number two, the panel has to determine whether or not there is a constitutional ground to support discipline. And number three, then determine whether or not you're going to recommend that Judge Peterson is sanctioned. So this is what I would ask you to consider. And reflecting back, September feels like a really long time ago, and it was. Judge Peterson, it was one of the first things that I asked her about, were these social media posts. And I would note that prior to testifying in this hearing, she had come to an investigative panel meeting in February of 2021, where she acknowledged nearly every single post that I showed her during the hearing. She acknowledged that they were her posts. I mean, we talked pretty freely about those posts at that time. But when we got in the hearing, I had a very difficult time even getting those posts into evidence, right? It was difficult. It was, well, I don't know if that's exactly what it said. Oh, well, this was posted on somebody else's page. I don't know. No, I mean, it was painful, and I know you all probably felt that way too, but it was painful. In fact, there were some of them that I could not even get into evidence based on the way that she was answering the questions. And I think that's something that should be considered. What we would expect of a judicial officer in this state, especially one who's been shown this information before and said, yeah, those are mine, is to come in here and say, yeah, no problem, put them all in. They're my posts. I've seen them before. We've talked about them before, but she can't do that. That's not who she is, right? We wanted to debate and talk about, well, I didn't put it on the Douglas County page and all of this, which is not what I asked, by the way. Something else that I would ask the panel to consider, there was a whole lot of, during the course of the proceeding, well, you just have that screenshot. Well, you just have that email. There were more. There were more posts. There were more emails. There was a video. There was an audio recording. Well, where are they? Right? Where are they? This is the question asked to the person that has access to all of those things, right? Well, for my post, well, they've been removed or deleted. Not there anymore, gone. The Cash App records. This is something that came up during the first day of the hearing. She pushed back on the statement that she made. It's in the transcript of the investigative panel meeting. I was wondering on that day why I was getting Cash App from people I didn't know. In fact, she tried to, I don't remember the exact statement, but essentially blame the court reporter. Like that must have just been taken down wrong because that's not what I said. And she actually said, and I asked about the records. They exist. I asked her to bring them. She said she would. Where are they? We don't have them. And don't you think if there was somebody, especially a judicial officer who had evidence relevant to their ethics proceeding, especially evidence that might help them, right? Maybe the court reporter did mishear, that they would bring it and that it would be produced. But here we stand and it has not been. She, at the investigative panel meeting, and I'll give her this, she said, you know what? At the time I made those posts, I was a judicial candidate. I didn't know they were problematic. I didn't know it was a problem. But in February of 2021, I've read the code and I understand. I've read the code now and I understand. The First Amendment argument, I'm going to skip over that. And I did not say this at the beginning, but I will stand on my written response to the First Amendment challenge, and I will stand on the evidence that is presented that I believe, as to nearly every single count, presents a genuine issue of material fact. So something else that came up, I didn't share the post on the Douglas County page. I'm not the one who did that. Some citizen that is out to get me, they must have put those up there. I'm not the one that did that. So that has never been the point for the JQC. It was never you put these things out there on the Douglas County page. The point is this: when you are an elected official or any kind of official, right, and you choose to have these settings on your social media set to public so that everybody in the world can come on there and look, you should assume, and this is just common sense, that anybody can screenshot them and that anybody can put them anywhere that they want. Those things are going to exist in those people's phones, iPads, wherever they have it, for as long as they want to hold on to it, right? So the point is not, I'm not the one that posted it on that page. I didn't go on there and ask those people for money. No, you didn't, but you went on your own page and you asked people for money when you were a judge-elect and you had your settings set to public. That's how it wound up on the Douglas County page for everybody to see, like, share, and make a mockery of, right? And that's when it started. And if she doesn't understand that now, she is not going to understand it. Right? The point was made, well, she testified, I didn't make money from these events I was promoting. Again, there was no allegation that she made money from the events that she was promoting. The allegation is she is using her judicial status to promote events at private businesses, right? And again, I think the wording of that rule is pretty clear, Rule 1.3. Do not attach your judicial status to anything related to a business or somebody else. And I would ask the panel, why else would you do that? What is the purpose of doing that? It's not to speak light over our lives. It's to say, look at me, I'm a judge. Wow, look, the judge is going to be at this club event where they have wine specials and appetizer specials. Great, I'm going to go. That's the purpose of the social media posts. Okay, I'm moving on to the next slide, counts 13 and 15, the HOA town hall. You all have the video that shows at least part of the HOA town hall meeting, and there are the rules that we allege she violated. The rule of professional conduct provision is the one about communicating with represented parties. Again, we have the First Amendment defense there. We have that Tammy brought up judge first, and we had Judge Peterson tell Mr. Lopez that it wasn't a negotiation. That is not what was going on. If what happened at that meeting is not a negotiation, then I don't know what is, because multiple times during the course of that meeting, and it's on video, if you do X, which was hold a special election, which by the way was one of the remedies sought in the pending lawsuit at the time. If you do this, I will dismiss that lawsuit. Multiple times during the meeting itself, and then as if that wasn't enough, staying afterward and asking again and mentioning, I'm a lawyer too. Your lawyer is giving you bad advice. And the respondent's position that she has taken before this panel is that that conduct doesn't violate the code First Amendment, right? It's absurd. Counts 19 and 21 on the next slide. This is the civilians into the courthouse. I will be very brief, and I think the panel covered it with the questions earlier. The point about the civilians into the courthouse is that Judge Peterson was told before she went in, do not do it. They cannot be security screened, and it is a violation of our policy. Civilians have to be security screened. A judicial officer is told that, but she can't accept it, right? That's just not good enough, the captain of courthouse security. So at some point, she calls the sheriff, and according to her, he gives her permission to go in and says the courthouse is secure. Well, I would ask you to ask yourselves whether or not it is then reasonable to call Captain Wilson again once you're already inside, right? And the time set forth in the video and on her recording that she submitted will demonstrate she's already inside by the time that call occurs. What person would? I've gotten permission from the sheriff, the head honcho. He's told me I'm fine to do it. What person then would turn around and call back to the person that said no in the first place, right? And not mention, by the way, your boss told me I could do it, so I'm doing it. Not mentioned at all. And during that phone conversation also, well, I got to make some phone calls. Click, that was at 2:08. We're already inside, and you hear the other wedding ending at that time. The civilians into the courthouse issue, I understand, is going to have to be resolved by this panel by weighing the credibility of the witnesses who testified before you during the course of the hearing. Judge Peterson indicated, and in their closing, they indicated, well, the deputies were doing it. They were doing it. Judge Peterson testified that prior to that event, she had no idea that the deputies were doing the weddings, right? So she didn't go there with the knowledge, hey, they've been doing it and letting people in, so it's fine for me.
Although part of the argument was someone right there and then was doing it, so how bad could this be? It's both, but there is some credence to, hey, this guy just let these people in.
Sure.
I'm letting 2 people in, not 9 people. I'm just doing the same thing this guy is doing.
Sure.
We're both officers of the court. Slightly different. I have a badge, you don't, but.
So the recorded call to Captain Wilson, he reiterates to her after he finds out that his deputy is in there and has let people in. He says, he is wrong and you are wrong. Okay. And it's something that should not have happened, right? But understand the point that you've made. Counts 19 and 20, or I'm sorry.
Next slide.
Yes. The 25 and 26, failure to provide records again. I would ask the panel to carefully consider observations of the witnesses as they testified. It's going to be a credibility call, right? Mr. Buchanan did not testify that, well, on Icon, I couldn't pull that up, or, well, the JQC didn't have enough information or any information, so I couldn't do it. That wasn't his testimony, and Mr. Alford testified. Neither of those things were ever mentioned. Nobody told me they could not pull them up. Nobody gave that as an explanation. The explanation was, you need to submit this request to this court on letterhead and explain why you need it, and ask the panel to review the note that was written at the time.
The Post-it note.
Correct.
Okay.
Counts 28 and 30, I have that titled Combined Courthouse Issues. And I would note that several of the counts, the way that they have been alleged, have bullet points underneath the allegation, and at the end of each bullet point, there is an and. And so essentially with my background in my head, I'm like, okay, it's charged alternatively, right? So if the panel were to find that any one of the bullet point allegations was sufficient by clear and convincing evidence to constitute a violation of the rule, it could do that and abandon. It could find one bullet point and abandon the other ones. And so that is true for counts 28 and 30. one of the things that I would ask the panel to consider, and there was significant questioning of Judge Peterson and issues during the course of this proceeding regarding her testifying. There were more emails. There was more to this. There were, those were there. I got them from IS. I gave them to my lawyers, yet somehow I had never seen them. And so that went on during the entirety of this proceeding. There is more, there is more, there's more. Let me talk about the more without having it here for you. And so what I think is important is that the evidence that is before you is the evidence with these emails and whatnot that and the director submitted. Nobody trained me on the panic button. I get that that is it is a silly thing, but what I would ask you to consider when you're considering whether or not her statement at the hearing, which was, well, I pushed it because my deputy was late and that's how I summoned them. There was a question, do you not have telephones? We know they have telephones. We know she uses her personal cell phone all the time. In fact, she told you that just a few days prior, she and the sheriff had a good relationship. And so she would pick it up anytime she needed something. She would just call him directly. Yet in this circumstance, when her escort is late, I'm not going to use a telephone then. Let me use the emergency button in my office. So I would submit to the panel that her explanation regarding that is not credible. 31 through 34, the contempt jailing.
You don't need to spend a lot of time on that unless there's something you particularly want to highlight.
So what I would like to highlight is I would ask the panel to read again the order that she issued at the time that she held PJ in contempt, because the rationale in that order is that she submitted false information to the court in 2016 when she filled out her marriage application. And in fact, her justification for doing it very much evolved when she was on the stand, especially under questioning from Mr. Lopez. It very much evolved, and it was the multiple occasions, false, fictitious, illegal document, or she said something in court to me during the hearing that was not true. Of course, none of that is reflected in that order, right? That was the explanation that she gave here. This contempt jailing is the second example of a time that Judge Peterson, during the course of this hearing, did say that she would have done something different, but it was only after being asked, right? And that is something that did not come up initially. It came up later on. And I believe the indication was, in hindsight, I would have held a hearing, set it for a hearing, right? But again, only after being asked and only after going through all of this and being here under oath at a hearing, do we say, you know what, yeah, I should have held a hearing. I will move on from that to counts 35, 37 and 43, the petition for your support. I just want to ask the panel to consider, and this was a common theme throughout the course of this hearing, the amount of blame that was placed on her staff. Like they were thrown right up under the bus as many times as they could be, right? And Judge Peterson, again, willingly, my people did it. Yeah, no, that was wrong. We heard her staff was wrong. We heard a lot of what happened with the staff. That is the prior judge's doing. That was what he did. And I didn't even know that that was going on. But once I knew, goodness, I fixed it. It shouldn't take the JQC noticing you, that there is an attorney that believes your staff intentionally backdated an order. It shouldn't take that to get you to change a policy in your court when you've been in office for as long as she had been in office by the time that this happened. That's not how this works. At what point, and I would ask you this, at what point, I know she was a new judge, but at what point did it become her responsibility? Because it sounded like when she testified, we hadn't reached that point yet. And when is it? When is it? Because when you throw your name in the hat, I want to be the probate judge, and the probate judge has a staff that includes a clerk, right? That is immediately your responsibility. I don't expect that there are not going to be errors, but there is a practice of manually adjusting your filing stamp backward to match whatever date the judge has written on the order, and you don't know about that until the JQC notices it, and you've been in office for over a year at that point. No idea that that's going on. Those people and the provisions in the code are there for a reason. There are certain provisions that attach to anybody that is subject to the judge's direction and control, and I would submit to you, that is her responsibility. It's her responsibility. I'm not asking you to find that there was malice, but I think there was a whole lot of incompetence, and I think that rests at her feet. Her attitude during the course of this proceeding was, it was cavalier, it was dismissive. During the course of testimony about the petition for your support, she actually, when I was asking her questions about, I believe it was the order appointing the private attorney at taxpayer expense to the woman and needed to respond discovery after the woman had missed the filing deadlines. But I believe her statement was, well, I didn't prepare that order. My staff prepared that order, but we determined that the signature on it was not a stamp. It was in fact her signature. She had gotten the order and signed it with an ink pen. And when I asked her about the order and whether or not she read it before she signed it, she said no and said it like it was nothing. When I asked her about the recusal on this case, when the attorney filed the motion to recuse and her knee-jerk reaction was denied. This isn't timely, right? Issues an order saying that. Then she turns around and voluntarily recuses herself. And when asked about why she did that, if she felt like there was no merit to the motion to recuse, why then did you turn around and step off the case? Her response was, I didn't want to be bothered. The petition for your support, and one thing I want to add, I recognize that a judge has the discretion to extend deadlines for filing. There was never an assertion to the contrary. The issue, and thus the violations of our rule prohibiting ex parte communications, which are 40, 41, 42, is that she did it and nobody bothered to tell the petitioner. She gave her 2 additional months, 2 months, after they searched on LexisNexis and found her and called her and started emailing and corresponding with her. Gave her 2 additional months and the petitioner has no idea. In fact, the petitioner's attorney and the paralegal that worked at that firm are calling that court constantly to inquire about the status of the order because they're thinking the deadline's passed, nobody filed anything. This is a ministerial thing at this point. The petition should be granted, right? What is the status? Well, it's in the last stages of review, the company line, right? Last stages of review. Here they are thinking, all right, we're going to get an order any day. Then they find out it's been extended for 2 months and nobody said anything. Nobody gave them the opportunity to respond. In fact, the caveat that was filed never even got served on the petitioner. It was scanned and emailed to the court. The petitioner found out after she called and inquired once again about the status, and the court ultimately sent it to her. And by the way, it was filed in past the second deadline that was given. So this whole petition for your support issue riddled with incompetence, riddled with ex parte communications. And once again, the obligation to ensure that your staff is not having conversations that you can't have is yours as the judge. The next slide counts 44, 46, 48, 49, the filing stamp. There is a reason the attorney that testified about the filing stamp and seeing the clerk adjust it backward, there is a reason that she assumed that that was done to make it appear as if that order had been entered prior to her filing that petition for writ of mandamus, right? And the reason is because the citizens out there, the bar out there, everyone out there knows this inquiry with Judge Peterson has been going on for, I feel like as long as I have been at this agency, right? It's been highly publicized. And there is a reason why there is a perception that the orders and the decrees of that court and the things that that court do are not above board. There's a reason she didn't assume, oh, well, you know, she's new. Maybe they just don't understand. That's not how this works. And I would ask the court to consider that and how likely it truly is that that order was signed after the attorney had been calling for weeks and weeks and weeks and been told, just waiting on signature, just waiting on signature. How likely is it truly that it just so happened to be signed about an hour after Judge Peterson was served with a petition for the writ of mandamus? Because that's what she testified to. And her clerk, yep, it was just a coincidence. right? Count 50, the habitual incompetence. I'm not going to spend time on that. It incorporates the counts that I have already covered. Grounds for discipline, I disagree with the respondent regarding which grounds may exist here. Ultimately, it's a panel determination. It's not a me determination. But my position is I believe there's evidence to support any one of these grounds. And again, I will not cover them, but I believe there's evidence to support all four.
Well, I think it's important that you flag there are four. There's not just willful misconduct in office. There are four, and they have different standards associated with them, but we'll certainly, per Coomer 2, be making sure we are careful in how we apply them.
And then to sanction, and I've covered already most of what I wanted to say about the sanction. Again, the purpose of the judicial discipline system is to preserve the integrity of and the public confidence in our judicial system. I think it's incredibly important, especially at a time like now, when the public's level of distrust of this system and all of us is at an all-time high. Somebody needs to know that not only that we're doing something, but that it is taken seriously. And our judiciary needs to know whether or not this conduct is acceptable and just how serious, not only the conduct alleged, but the conduct during the course of this proceeding, just how serious that is to this panel.
What is this quote from?
So this is also pulled from Coomer. And again, it's just something that I really couldn't say any better myself. We do not expect judges to be perfect. They are human, but we can and do expect them to be honest. The judiciary has no place for dishonest persons. And throughout this proceeding, looking back at the transcripts, reading it in black and white, it's shocking. And she does what she does with ease, which is, I'm asked a question, I'm not going to answer that question, but I am going to give you 5 explanations, right? Some of which are not even relevant to the question that you have asked me. And repeatedly, she had to be redirected to the question. At one point, one of the panelists had to ask her a question 3, 4, 5 times, never got an answer. Is that conduct acceptable for a judicial officer in this state? Is coming to an ethics proceeding as a judicial officer and talking all about all kind of evidence that is out there that apparently contradicts the director's evidence and is helpful to the judge, referencing it, and at least some of it saying it's there, it exists. Is not bringing that acceptable to this panel? Is that behavior acceptable of a judicial officer? I would expect it of a criminal defendant. This is nearly my last slide, and this is the footnote I referenced earlier. Also from Coomer, having already concluded that Judge Coomer violated several provisions of the code through his actions before the inquiry, we consider his actions during the JQC process as an aggravating factor only in determining the proper sanction. I will conclude with this. The public is watching this, especially the taxpayers of Douglas County. And importantly, our judiciary is watching, and both are wondering, to the JQC, is this conduct acceptable of a judicial officer? And if it is not, well, just how serious is it? And I would submit to the panel that the behavior during the course of this proceeding, with the exception of the jailing the woman who wanted to fix something from a marriage application several years prior, the behavior during the course of this proceeding is just as serious and should be just as concerning as any of the other behavior contained in the formal charges. Again, the power of our courts and of our judges is to make decisions. You issue rulings, you issue orders. And what you hope as a judge, I'm sure, is that even if a party disagrees, and I'm on the receiving end of an adverse decision, there's still some respect there for the institution, right? I disagree with the order of this court, but I'm going to respect it. The institution, the judiciary, should have that level of integrity built into it, right? And so when we have a judicial officer that consistently and publicly does things to chip away at the public's confidence in the judiciary and in the decisions that it makes, it does harm to everyone. And it's not just harm to the unfortunate people who have already encountered her and who have had their petitions pending for a very long time with no explanation. And it's not just harm to the person who had an uncontested request of that court, and there was just a ministerial action that had to be taken. And during that time, they had to foot the expenses of their father because they had no access to the estate, right? It's not just the harm to those people, it's the harm to the institution as a whole. There are bad actors in every profession. I don't intend to beat up on judges, but it makes the lives of our jurists who show up every day and do the right thing and try to do the right thing all that more difficult when we have one who refuses to do it. And oftentimes it's just because she can't, right? When she does not get her way, when somebody disagrees with her, I am going to sue you, or you should retire. This county has outgrown your spirit. How are you even a judge, right? That's the response. I'm going to blast it off to everybody so they can see these things I'm saying. The response to IS when they're not doing what she wants is notice of intent to sue, accusing them of obstruction, right? Obstruction. And if you do not do what I want, I am going to start legal proceedings. Is that her right? That's her right. It's anybody's right, really. If you feel like you've been wronged, you can do it. But to resort to that as quickly as she does in so many circumstances, that should very much concern this panel. And one has to wonder about going forward, her decision-making ability. If you have an individual and their personality is such that anytime there's pushback or not doing exactly what I want, I'm going to push back 10 times harder. I'm going to threaten legal action. And with civilians, I'm going to ensure that everybody knows that I'm an attorney, right? She's a bully, right? And that is what she resorts to. That is not something that can be trained out of a judicial officer like this. It's not going to be fixed by sitting at home for 90 days and being suspended. And unfortunately, it's just not. And so in my view, the only thing left is removal. Had this proceeding gone differently, and if the transcripts were not replete with, and the presentation of this case were not replete with a judicial officer who was not being candid with this tribunal, and cooperated with the process and came in, and there's not an expectation that you admit that everything we've alleged you've done and it violates the code, but if there's some level of acknowledgement, some acceptance of responsibility, then perhaps you could have some faith that going forward things would be better or a little bit different. But I don't believe that you can or you should have that faith. And so if you're left with knowing that nothing is going to be different, if we are dealing with somebody that's going to do what they want, regardless, removal is the only answer. And again, it's about the public and it's about the institution. Thank you.
Thank you, Ms. Veal. We have reached the end of the proceeding. I appreciate everyone's patience with some of our technical glitches. Will you, Ms. Veal, work with Ms. Willoughby to sort out the transcript? And then obviously we need to get that, the record comes later, but we need to get it to Mr. Tate as well so that everyone's got it. And then we will be working on an R&R, and we'll get with the Supreme Court Clerk's office about how to more pleasingly deliver the record to the Supreme Court. Do you have anything else on behalf of the director's office? Mr. Tate, anything else on behalf of Judge Peterson?
Do not. I just want to clarify, and let me first say, this is not a request to submit anything else, but we don't need to submit anything else. I know in the past, I've been asked for proposed findings of fact or all that. I just want to make sure I'm not requesting that.
No, I
Make sure-
appreciate that. And we'll keep that internal unless we have questions. If there are things where we think it would be helpful to hear from, it would always be from both sides. And it may be that one side says, I don't need to weigh in on that. But if we are at an impasse on something where input from the two sides would be helpful, we'll certainly solicit that. But otherwise, we've received ample input from both sides, and I think we've got a record with which to work and some work to do. And we'll certainly undertake that right away. Okay? Thank you, everyone.
Thank you.
Before you go, I just wanted to double check. It's shared tip down between Ms. Veal and Mr. Tate.
I think that it's paid for through Ms. Veal's office. I don't think Mr. Tate has to pay anything. He will get a copy of it, but it is the responsibility of the JQC, of which Ms. Veal is the representative right now, to pay for the transcript. Is that correct?
Yes.
Correct.
Okay.
Okay, gotcha.
Thank you, Mr. Veal. All right. So did that answer your question, Ms. Willoughby?